Okay, well, let's talk a little bit about asset protection planning. You know, over the last several years, that's become a very hot topic. And I think there's really two reasons for it. Basically, we have a proliferation of lawsuits in almost every area of the law. And some of that is because we have too many lawyers who are plaintiffs' lawyers. And they're looking for a way to increase their revenues. And so they come up with novel theories of tort and other types of actionable claims. And we have a lot of aggressive plaintiffs' lawyers out there that are looking for deep pockets. Secondly, I think in our society today that we've become a little bit, and probably too much, victim-oriented. And we feel like, the society feels like people ought to be compensated or victims ought to be taken care of because of the things that happen to them, many of which are unfortunate. I remember that movie, Forrest Gump. And you remember Tom Hanks is running in Colorado, and he comes to a little town in Colorado, and somebody comes out and they've put a little sign on their chest that says, "S happens." You know, and Forrest goes, you know, that would be a great idea for a t-shirt. Well, we've all seen that t-shirt and that sign, you know, obviously that became a big thing in vogue that, you know, S happens. So, but in our society, we apparently, when S happens, we want to have some sort of compensation as a result of that. And who would have ever thought several years ago that if you spilled coffee on yourself in McDonald's, that McDonald's would be responsible? I mean, it's hot, and you're a mere mortal, and you're likely to spill coffee, but McDonald's should tell you that, and should provide a way to avoid that in some way, and because they don't, then they can be sued. So, and then we have another additional layer of I have several clients who are major players with Fortune 500 companies. And they're worried about liability as a director or an officer of a public company. The Enron, and Enron, by the way, there were some people who were really guilty, but there were some people who were on the fringes who were exposed to liability too, and they maybe didn't really know anything that was going on. And they weren't really directly responsible, but because they're in the loop in some way or another, they face horrendous liability exposure. So over the last several years, this asset protection has been something that everyone's concerned about. But it's not new. It started really many centuries ago, back in England, when the corporation concept was developed. And why do we have corporations? Because people want to be protected from the business risks that would otherwise subject their personal assets to liability. And so the corporate concept of providing a shield against liability was a societal purpose that was codified and made into law. And now we have a corporation, and nobody thinks anything's wrong about incorporating to protect yourself against personal liability. And believe it or not, even though there are cases where the corporate veil can be pierced, and by the way, as professionals, accountants and CPAs and lawyers, we can't use a corporate shield. Cases say, you know, you can practice out of a corporation, but if you're a CPA or you're an accountant or you're a lawyer or you're a doctor, you're personally liable, and that's the way it goes. Now, we can try to protect ourselves against the liability of our partners, but we can't protect ourselves against our own malpractice. And so we don't have a shield of liability to protect us. We are in a position where we're always exposed and continually exposed. So we have to be very careful, not only about how we practice, but how we protect our assets. over the past several years, there have been, starting back with the Subchapter S Corporation that was put into play in order to make it a pass-through tax entity, and all of you understand that. It has given us a little bit more flexibility with respect to how a business entity can be taxed. And that's important because, and we'll talk about that in just a minute. Let me just go through, my assistant decided that what I should really be is one of America's most sexy attorneys. And they thought that picture looked more like me than really it does, but so this is an actual picture. But, eat your heart out, George. Let's talk about what a definition then of asset protection planning is. Setting up and arranging one's assets and affairs in the most effective way so as to protect and safeguard them from risk and any creditor's claims to which they would otherwise be subject. Now, I like to think that asset protection is really part of estate planning, because when you talk about asset protection in and of itself, you've got the problem of the fraudulent conveyance law that we'll talk about in just a second. But what that means is that if we arrange our affairs and transfer assets in such a way as to impede, hinder, or defraud creditors, that the transaction can be set aside, that transfer can be set aside. And so one of the ways to determine whether that intent is there to defraud creditors is, why did we do it? What was the motivating factor behind the transfer or the business arrangement that we set up? So that's why I like to refer to it as estate planning and not asset protection planning. So I tell our clients, we're not doing asset protection planning, we're doing estate planning. And fully integrated estate planning involves the orderly disposition of assets at death in the most tax favorable manner, but it also, at the same time, we attempt to preserve, protect, and increase our assets during our lifetime. That's part of estate planning too. And that then includes the concept of asset protection planning. Now, we know what the strategies are with respect to basic estate planning. There's wills and trust and durable powers of attorney, healthcare directives, and then there's a whole multiple array of different sophisticated estate planning techniques like GRATs and ILITs, irrevocable life insurance trust, and others. And then you also have protection against business and real estate claims that in the parlance of estate planning and asset protection planning that we refer to as inside debts. And then there's protection against personal claims that are the outside debts. And maybe we can talk about that in just a couple of minutes, and I'll give you more specific definitions of inside and outside debts. We have entities that are set up to protect against business and real estate liability: corporations, limited liability companies, and family limited partnerships. In California, it's there aren't any tax implications, either state or federal, but when you transfer a real property into an LLC. And we tell everybody to do that. Any rental property or income producing property in California, we tell you got to get it into an LLC, because you don't know if insurance is going to be enough, if you have enough coverage, or if there's something that could happen there that would be outside the scope of the insurance coverage. For example, we had a client come in a couple of years ago. They owned a fourplex in Long Beach, and which is in southern LA County, in a big port city. And there was a murder there, and they were the property owners of the fourplex. They were being sued for $7 million by the victim's estate. for a wrongful death because they didn't provide adequate security and proper lighting. Now, who would have ever thought that somebody, if you're a property owner, that you could be sued because one of your tenants was murdered or somebody visiting them was murdered? You could be, but you would have liability for that. Well, obviously their insurance policy was beyond the scope of their insurance, and it was probably outside an exclusion from the insurance package itself, the way it was, the way the lawsuit was framed. So they didn't have any protection. So if they had owned it in an LLC, however, the good news is that they could have only gone against the property itself. They could have only gone against the LLC. They couldn't have gone against the other assets, personal assets of the landowner. So that's why it's incumbent upon us as professionals when we have clients who own real estate to make sure that that real estate is protected, that it's isolated, that claims against one parcel of real estate are protected from assessment against other parcels or other personal assets of the client, of the property owner. And we do that by means of an LLC or a family limited partnership. Now in Florida, there's some particular state tax consequences, and Steve can probably elaborate on this, but I understand that there's a documentary transfer tax that you have to be careful of here. In California, that can be avoided because if you are 100% owner of the property and you transfer it to an entity of which you're 100% owner, then there's no tax and there's no step up for assessment purposes in the real property tax either. You avoid that. But Steve tells me that one of the ways to get around that, and I'm not going to elaborate on it and let him talk more about it, but is by forming a land trust and then taking the property out of the land trust and putting it in the LLC. That can be a way of maybe avoiding taxes here in Florida. But you know, in the old days, people used to come to me and they'd be partners in owning, there'd be 2 or 3 different people that would be joint owners of property. And they'd either own it as tenants in common or in a partnership. You don't see partnerships anymore. General partnerships are a thing of the past, unless they're partnerships of entities, like partnerships of LLCs or corporations or something like that. But you don't see general partnerships anymore because you're not only liable, you're not only personally liable for any claims against the property that is the major asset of the partnership, but your partner could have a claim that could come back and haunt you. So now people don't do general partnerships. Either two brothers or a brother-in-law and his friend or family members, we don't do general partnerships anymore. And it might even be, I hate to use this word, malpractice if you don't advise your client to get out of that. So we now see a lot of LLCs and family limited partnerships that give you this aura of invincibility against creditors who try to go against your other assets other than the asset inside the entity that holds the real estate. So inside creditors are those creditors whose claim is directed against the business operation or real estate which is operated and owned inside a business entity. Typical example, the slip and fall at a rental property. That's an inside debt. It's a debt against the entity itself, and you want to try to protect against that by not only insurance coverage, but maybe putting that rental property into an LLC or a limited partnership. You never, ever put real estate into a C Corp. Why? Because when you try to take it out, you've got a double tax problem. The only times that real estate is put into a C Corp is if it's a public company. And they may own property in a C Corp, but a small business, a closely held business is never going to own property in a C Corporation. And I don't think it's good to put real estate in an S-corp generally either. It's more it's not as bad. There's ways to, you do avoid the double tax in most instances, but there are some, it's much more flexible and easier to have it in an LLC or a limited partnership than in a sub-S. But the sub-S, there's a big difference between holding it in a sub-S and a C-corp. A C-corp is no, you never do it. We had a client come to us, and they were going to incorporate their business, and which was a good idea. I don't know why they didn't do it before, and they owned the real property upon which, and they considered that to be part of the business. And we said, hey, wait a minute, you don't do that. What you're going to do is you're going to put the real property into an LLC, and we'll incorporate the business, and the corporation will then lease the building from the LLC. And that accomplishes several things. It gives you better tax results. It isolates the assets so that if somebody sues the business, they can't go against the property too. And it also is better for estate planning purposes. You may be able to gift some of the interest in the LLC that holds the real estate and get a minority discount and gift it to your children or to other family members. And it can also, if you want to sell the business, you can retain the ownership of the property. So that's a smart thing to do. We even do it sometimes with the major assets. You know, dentists lots of times have more equipment than doctors. You know, the doctor just has a stethoscope and that's about it, lots of times. And the doctors rent a lot of their equipment if they have anything more sophisticated. But dentists usually own a lot of their dental equipment, and so we sometimes take that dental equipment out of the dental practice and put it into an LLC that leases it to the professional corporation that is the dental practice. Then if there's a lawsuit against the dental corporation and the dentist, he may be able to have safeguard the equipment, which is the major hard asset of the practice, and keep it segregated from the claims against the business itself. Okay, so inside creditors, how do we protect against inside creditors? We use insurance and we use liability protected entities. And that's how we protect against inside creditors. And we try to segregate out some of the assets of the business entity so that we don't have all our eggs in one basket. We try to take out some of the assets if we can and segregate them from the business the other business assets. Okay, what are outside creditors? Well, outside creditors are those creditors whose claims arise outside of the purview of the business entity and are generally asserted against the business or real estate owner personally. For example, malpractice claims are outside debts because they can be asserted against you personally. Let's say that our friendly landowner is driving down the street here and on Kennedy, and he hits somebody and knocks them over the bridge. Well, that's an outside debt. It's a personal liability, and he's going to be personally liable for that. If it goes beyond the scope of his insurance, then it's not a debt that is against the business entity, it's against him personally. So that's what an outside debt is. Now, and when we're talking about asset protection planning, or as we like to refer to it, quote, fully integrated estate planning, we're concerned about both inside debts and outside debts. We want to protect our clients from both of those kinds of problems. Inside debts, like I said, operating business, C corporations, S corporations, limited liability companies. You're all experts here on C corps. You know that that's a taxable entity that's separate from the individual owner. It's commonly created to shield shareholders from liability. It is subject to double taxation since the C corp must pay taxes on its income, but in effect, then if you have passive shareholders who are not employees, it's hard to get the money out to them without it being a dividend. And so you can sometimes in a closely held situation get around the double tax problem by paying it all out in salary, all the profits out in salary, and the corporation gets a deduction for that, and then the individual pays the tax as an employee, and there's not a double tax problem. But if you have shareholders who are non-employees, then you have a problem about how to get with a C Corp, about how to get the money out to them without it being dividends. And of course, dividends are not deductible, and so you have the double tax problem there. S Corps are similar to a C Corporation. By the way, does the state of Florida know whether you're an S Corp or not? Not really. The Secretary of State's office or whoever, is that, Steve, is that you incorporate through the Secretary of State? They don't know if you're a C Corp or an S Corp. So legally, there's no difference between a C Corp and an S Corp. It's just an IRS difference. It's a tax reporting difference, but it's not a legal difference. And a lot of lay people don't know that, and I suspect that maybe some in your profession don't understand that too. You don't have a special articles of incorporation for an S Corp. They look just like the articles for a C Corp. In California, by the way, we don't deal with the Secretary of State's office personally. Now, I hope it's not the same here as it is in California, but in California, you know, people think the people who work for the state, they forget who pays their salary.
That's universal.
And well, it's not universal because I've done some business in other states, but I suspect it may be the same here. But they forget who pays their salary, and so it's almost an adversary situation. But we don't deal with the Secretary of State's office. We have an attorney service that deals with them. And we send all our articles, because if we mail it into the Secretary of State, we may never get it back. Or nobody knows where it is. So we mail it into, it probably is similar here, but we have an attorney service who hand carries it over, all the documents that we want filed, and then they go back and pick them up and send them to us. And we get them back in a reasonable period of time. Otherwise, we never know what the hell happens to them. And when we call, we get insulted because we're dumb enough to not know where it is. And so that's the way we handle it. S Corps, there's a pass-through. Now, by the way, there are some questions about whether to use an LLC or an S Corp. A lot of accountants argue with me that an S Corp is better because of the self-employment tax issue. LLC income is deemed all earned income, but S Corporation is dividend. And therefore, there's no self-employment tax on distributions from an S Corporation. However, the IRS doesn't like that because they want you to pay the self-employment tax. So lately, in the last 5 years, they have aggressively been coming and saying, hey, this is not dividend, it's salary. You need to pay yourself a salary in an S Corp. That's earned income. So you're going to have to pay the unemployment tax on it anyway. So I don't think there's much difference tax, and even the savings is only $1,000 or $2,000 a year at the most. And there are some disadvantages with an S Corporation. For example, if the S Corporation borrows money, it doesn't impact on the basis of the shareholder. Whereas in an LLC, if the LLC borrows money, it increases the basis of the members or partners. Also, if one of the members of the LLC dies, you might be able to get a step up in basis because it's treated tax-wise as a partnership. As an S Corp, you don't. You don't get any kind of a step up in basis. So there are some advantages to having a LLC over an S Corp. Limited liability companies it's a complete pass-through. It can either be manager managed or member managed, or you can have a single member LLC, and that's disregarded for tax purposes. And it's taxed like a sole proprietorship on your tax return. If you have a member managed LLC, what does that really look like? A general partnership. If you have a manager managed LLC, what does that look like? A limited partnership with a general partner. So I remember I had a client come to me a few years ago, and they had an LLC, and they had, over a period of time, brought in a lot of new members. What they did is they developed a software system for hotels and resorts for their credit card transactions. And they had representatives all over the United States, and so each one of the representatives had their own clientele, and so they all were a member of the LLC that was the operating company. So that's the nice thing about an LLC. It's flexibility from a management standpoint. One of the nice things about it. Now, family limited partnerships, the problem with a limited partnership is that the general partner is personally liable. So if you want to use a limited partnership, you usually have to create two entities. And a limited partnership is chartered by the state, just like an LLC. A general partnership is not, by the way. But a limited partnership is chartered. But it has to have a general partner, and that general partner is personally liable. So nowadays, you don't see an individual being the general partner of a limited partnership where the limited partnership is conducting business or owning real estate. You have to form an LLC or a corporation to be the general partner. Well, if you're going to do that, it might be better to just start off with the LLC. And then you wouldn't have the expense and the inconvenience of having to have two different entities. Now in Florida, there may be a reason for having limited partnerships, however, because I think the Florida statute on the charging order is more favorable to limited partnerships than to LLCs. And so you might, that's an interesting point that you might want to check out with somebody knowledgeable like Steve. Sometimes it may be better to have each of the spouse be a partner in the LLC, be a member of the LLC, rather than to have a single member LLC. So you can start off by having each of the spouses be 50% members. And if for example, if one of the spouses is an attorney and one is not, that may be a good idea, because the spouse is not liable for the torts of the other spouse. And the community property in California is liable, but the separate property of the spouse is not liable. So one aspect of, quote, fully integrated estate planning or asset protection planning is marital property division. That's done before any claims arise, so it can't be subjected to any claims of fraudulent transfer. So if you plan in the beginning, if you put the asset into the name of the spouse who is less likely to be sued or to have a claim against him or her, then that may be a wise thing. There are a couple problems with it though. Number one, what's good for the goose is good for the gander, and what's good for asset protection planning is also good for divorce. And so if there's a subsequent divorce, that separate property is going to be upheld by the courts in a divorce situation if you've done it right for asset protection planning purposes. The other thing that's a problem with that is that you may not get a fully step up in basis upon the death of the spouse who is most likely to die and have claims against him or her. Whereas if it was held in his or her name alone, or in California, if it's held as community property, it gets a step up in basis, the entire property. And that eliminates this capital gain on death. So anyway, again, you just need to think it through. You need to put the pencil to the paper. And you need to have somebody knowledgeable and that's in a position to be able to review things and make a determination of, is that the best thing to do in that particular system? For that particular client. Real estate assets need to be protected. Warning, jointly owned real estate should generally not be held as individuals or in general partnerships. There's tremendous liability potential. Strongly consider LLCs or family limited partnerships. Okay, now let's talk about the charging order. And you've heard probably a little bit about this before. And a lot of people hear about it, but they don't really understand what it is. A charging order is a remedy that a creditor has against the member of an LLC where they have, if it's an outside debt, if it's a personal liability. So for example, if I have a client who has been involved in an automobile accident and there's a large claim against them, and they own an LLC, the theory is that the creditors is limited to a charging order which is like a garnishment of wages, and it attaches to any economic distributions that are made from the LLC. And the charging order says, if there are distributions made from the LLC, the distribution of member A is to go to the creditor, not to member A. And that theoretically is the exclusive remedy of the creditor. So it's worthwhile when you're setting up an LLC to see how it's going to be interpreted, the law, with respect to a charging order as applied against that creditor, that member. And that's why you need carefully to be associated with an attorney who understands and knows the difference in the charging order and how it's going to come about. Charging orders came about in ancient England because one of the partners would object if the creditor got through to the assets of the partnership. And he would say, well, it's not my fault. That's partner A you've got a claim against. I'm partner B. You're interfering with my rights and my business. And the court said that's true. And so through a series of common law decisions, and it was finally incorporated in the British Partnership Act, and it was brought over to the Uniform Partnership Act in the United States in the early 1900s. And so this charging order concept came about to protect the interest of the other partners. And the court, the reason is that the statute was enacted and that the courts originally gave that benefit was to protect the interest of the other partners. Now, query, what if you only have one member, a single member LLC? Then what's the purpose of the charging order? Again, if you go back to the history, and the purpose of the charging order is to protect the rights of the other members, the other partners. And this is exactly what the bankruptcy court in Colorado said when there was in the Albright case. And they said, if you've got a single member LLC, there's no basis for applying the charging order remedy. We're going to let the bankruptcy receiver go directly against the assets of the LLC, or and by implication, if a regular creditor went against that partner, that they'd be able to go directly against the assets. So you have to be careful of a single member LLC. What does the single member LLC do though, however? It doesn't mean you forget about it, because it still protects against what? Inside debts. It just doesn't protect against the outside debts. But it does protect against the inside debts, the claims against the property itself. It isolates those debts and protects your other personal property and real property from claims. So if you've got a slip and fall case, they can only go against the property inside the LLC. They can't go against your other assets. That's an inside debt. If they have a personal liability and it's a single member LLC, then the creditor is going to probably be able to get more than just a charging order. They're going to probably be able to get and foreclose on your member interest and take over the LLC, if you follow the logic. There's a lot of favorable jurisdictions. Delaware, Alaska, and South Dakota are very good. Arizona and Nevada are exclusive remedy states. One of the questions comes up is, will Florida, if I have, let's say I'm a Florida resident, and I have a Delaware LLC in which I place my rental property, and I've got another, say, 10% member who's an individual separate from me. It could be my brother, or it could be it could be a friend, or it could be just a business associate who has a 10% interest. And the creditor tries to get more than just a charging order. And our debtor says, well, but under the law of Florida, I mean of Delaware, you can't, and this is a Delaware LLC, it says specifically that the exclusive remedy is the charging order. And it allows the operating agreement to have provisions in it that, for example, they can issue a penalty if anyone tries to interfere with the management and force a distribution. There are some other things in the Delaware statute. And so then the Florida court is saying, are we going to apply Florida law or are we going to apply Delaware law in this case? And there are no cases that for sure make that clear what they're going to do. So, but would it be better still to have maybe the Delaware LLC than the Florida LLC? It might be, because it gives you more leverage. That's an issue that has to be litigated. My partners are litigators. Oh, I feel sorry for them. They're a little perverted. But they are litigators, and they sometimes represent bankruptcy trustees. And so they come to me and they say, with people who have a system or a plan in place, and they have me analyze it. And if they come to me and this guy's got a Nevada LLC or a Delaware LLC, and they're going to say, can we bust through this? I'm going to say, yeah, maybe, but you're going to have to litigate it. It's going to cost some money. Well, how much money is it going to cost? Well, if it goes all the way through, it might cost as much as $100,000. So I'd lower your settlement by $100,000, because that's what's going to take to get this, to try to get a judge to go along with you. It's going to take that in legal fees. So you have much more leverage, and it gives you, in dealing with creditors, if you are in the proper jurisdiction and if you're protected. That's why you forum shop. It gives you leverage. Recently, Delaware and Nevada have enacted a new legislation called Series LLC. And what that says is that, what the statute says is, you can develop a master LLC, and it can have subdivisions or series within it. And each series is treated independently from the other series for liability purposes. So let's say you have a client who owns 14 different pieces of real estate. They can create one Delaware or Nevada Series LLC, and they can place each different piece of real estate within one of the series. And Series 1 is not liable for the debts of Series 2, et cetera, et cetera. And so that could be a very beneficial thing if you have a client who wants to be able to has multiple properties and doesn't want go to the trouble and the expense of creating multiple entities. You could have one entity. Now, as accountants, I'm sure you're already thinking, well, do you get one ID number or do you get several for each series? Do you file one tax return for the master, or do you file a separate tax return for each separate series? The answer is no one knows. So I guess you do whatever you think is right and most convenient. And you could do it either way, and it would probably be acceptable. I've read a couple of articles by CPAs that have, scholarly articles that have said that, you know, it's a matter of choice. You can either do it as one return, because you'd actually, if they were owned as a proprietorship, it would all be on one 1040 return. Or you can do it as treat it as a separate return for each, and you can even have different owners of the different series. So that's something to look into. One of the problems is, and why they're not used more, is that we don't know that Florida is going to uphold the validity of a Delaware or Nevada LLC. We don't know if California is going to do that. So lawyers are reluctant to try to underwrite that and give an opinion as to whether it will be upheld. So until there's case law, then it may be something that would be, it's too ambiguous and uncertain. My thought is, personally, that I think that most states will uphold it, because there's no overriding state purpose behind not upholding it. And what's wrong with discouraging multiple entities? I mean, I don't see any real overriding societal purpose that would discourage it. Okay, I want to move right along because we're almost done here. I talked about the fraudulent transfer law. Again, that grew up out of the fact that people would try to transfer assets to friends or insiders and family members in order to avoid creditors. And the law grew up that, and the fraudulent transfer law is designed and aimed to keep that from happening, to setting aside those transfers if they're done to defraud, hinder, or impede creditors. Where is that, if you were to draw a spectrum, the fraudulent transfer law really comes into effect at this end of the spectrum when the facts occur that give rise to the claim. Not when the lawsuit is instituted, not when the judgment is handed, but when the facts that give rise to the claim happen. At that point, for example, when you sign a guarantee, at that point then you've made yourself liable for the full amount of the guarantee. And it may not be in default, but you still have to look at that for purposes of the fraudulent transfer law. If you've done something, it's easier. What it comes down to is the further on down you are in the spectrum towards the judgment being rendered, the easier it is for a creditor to say that what you've done, your transfer, is fraudulent. The closer you are to having where the facts occurred, the harder it is to prove that. And if you're on the other side of where the facts are, you should be okay. Unless you have, there's a direct causal link, like you're negotiating with a bank to sign the guarantee in 2 weeks. That would probably be close enough to make you on that side of the spectrum, on that side of the line. But if you're a professional and you're practicing and you do something here and then the malpractice occurs here, you should be okay, unless you've done it in a wanton, disregard, and reckless manner, which none of you, I can tell, would ever do anything like that. Okay. This is a listing of different techniques for asset protection, with 10 being providing the most protection and 1 the least. We don't have enough time, much time to go into too much of that, but let's move on, because I've got, what is not a viable alternative? Secrecy or hiding of assets, that doesn't work. You don't asset protect based on secrecy or hiding of assets. It doesn't work. Why? Because you're going to have a judgment debtor exam and they're going to find out about it, and it's going to make you look bad too. It's going to make the client look bad if that's what they've tried to do. So Nevada or offshore corporations utilizing bearer stock, that doesn't work. Disclaimers don't work. You can check with the Florida lawyer about marital property planning. I've already talked about that, where you might want to divide property up and have the spouse that is least likely to be sued be the direct owner of some of that property. Again, the caveat, be careful of divorce, and also the issue with that step up in basis. Domestic asset protection trust. Now, I want to just finish up with this, and very rapidly, but it's important. Several states have enacted legislation that allows for favorable treatment against creditors for setting up a domestic asset protection trust. And so what we do is we kind of use a modular concept. I think we've got that down here, where we have a domestic asset protection trust and the member interests are held, they create the LLC. So they may own 95% of the LLC, and then our client is the beneficiary of that trust, but it's set up in a proper way. And then there may be another 5% member, a third party. What is the benefit of doing this? Well, let's say you're a creditor and you come against the client. First of all, you have to get the judgment against the client. Then you have to get a judgment against the trust, because the client doesn't own the LLC. So you have to go against the trust. And the Nevada and Alaska and Delaware laws are very favorable to debtors and against creditors. So it's very difficult to get a judgment. Now, if you have just a regular Florida living trust, they're going to be able to bust right through that. But a domestic asset protection trust, they're going to have problems. And then they might, even if they do get the judgment against the trustee of the trust, they still have the charging order problem then. They may still only end up with a charging order. So this is a very good setup. Now, if you really want the maximum protection, what you do is you make the trust a foreign asset protection trust. You put it offshore, and you make the LLC an offshore LLC. And you actually fund the LLC offshore set up a bank account in the name of that offshore LLC. Then what are the problems? Well, let's say that you get the creditor gets a judgment against the client. They have to go to the Cook Islands, say, to enforce that judgment. The Cook Islands has a different standard of proof. It's beyond a reasonable doubt as opposed to preponderance of the evidence. The best example I can give you of that is the O.J. Simpson case. He was found not guilty because apparently it was beyond a reasonable doubt that he was guilty. But it took the civil jury, when they sued him for damages for wrongful death, 2 hours to come out with a verdict of guilty. The reason is it only had to be 51-49 in the civil case. In the criminal case, it had to be 100-0. Well, in the Cook Islands, the civil law standard is 100-0. And so they'd have to retry the case against you there because the Cook Islands does not recognize American judgments. And in the Cook Islands, you have to place up a bond. It has to be tried. Only Cook Island lawyers can do it. And so it's going to cost and take a lot of time. There's also a statute of limitations problem that the creditor is going to have to face. Then, even if they do get a judgment there, they would still be faced with the LLC problem. And let's say that the LLC is in Nevis LLC and the money is in Hong Kong or Switzerland. They're going to then have to go against and try to get, and the Nevis law is very clear that they're limited to the charging order. So this setup is much safer than just with the domestic asset protection trust. Because why? Because an American court cannot get jurisdiction over the offshore, and they can over the domestic. The domestic, though, does provide a substantial hurdle, an obstacle. And the problem with going offshore is that, if the only reason you're doing it is asset protection, it kind of smells a little bit. And there have been some cases where the judge has incarcerated the client until they force an expatriation of the assets. However, in those cases, which, by the way, the clients it was an issue where they were both crooks and clearly bad people, but also they didn't do it right. They didn't set it up. They still had maintained control, and they were not given good advice. And one of them happened in the Cook Islands and one didn't. And the one that happened in the Cook Islands, they never did get the money from the trustee. The trustee never gave in, and they threatened to bring the Marines over there. It was the FCC, and they still didn't get the money. The guy stayed in jail. Now, you don't want your clients to have to go to jail, but the guy didn't get the money, and they finally let the guy out after 6 years. And they said it doesn't do any good to put him in jail, I guess. And I'm sure they're monitoring the assets and trying to find out where all of them are, but the trust company stood up to the U.S. government and said, no, we're not going to give you, we're not going to give you the money. We're not going to take action. If you set it up right, the more control that the client has, the easier it is to pierce this. And so the client has to weigh the alternatives. How much are you willing to give up to make, and how much do you want to keep? And some clients, it might be better just to use a domestic asset protection trust because they don't have any international flavor. As you know, there's a lot of filing requirements on foreign trust. However, I don't find that to be a big burden because we know how to do it, and we work with CPAs who become knowledgeable with it. And and the IRS actually appreciates people who file those things. I've had the IRS call me up just randomly and say, by the way, we noticed that you're an attorney because we've seen on the documents. Thank you very much because your client is a good and responsible citizen. And thank you for structuring this in the right way. Because what are the IRS concerned about? Asset protection planning? No. Tax evasion. That's what they're worried about. So that's why offshore entities have this bad name, is because people use them to try to avoid taxes, evade taxes. But if you pay your taxes and file all the forms, then there's no problem. The IRS doesn't have a problem with it at all. And more with the value of the dollar now, And with the global economy that we're in, more and more of our clients are doing investing offshore and doing things offshore. We're more international now than we've ever been. And so it's a more realistic thing to do. This is the ultimate asset protection planning against outside debts, personal liability. So this would be what doctors and lawyers and CPAs and corporate executives, and they would look at something like this, either using a domestic asset protection trust or an offshore trust. If they're using an offshore trust, they should have liquidity enough to put money offshore so that there's no way a court can have jurisdiction over that. Because if they just have property here, then again, the court can find some way maybe to get to that property. But if the property is offshore, they probably won't be able to get it. And so on a scale of 1 to 10, the foreign asset protection trust is going to be up near the 10, where the domestic is only going to be a 5 or a 6. But it's, a 5 or 6 is better than being a 0. And it's going to give you a lot of leverage. And again, I see these kinds of situations because we represent creditors. And I know that decisions are made with respect to settlement and how hard to pursue and aggressively to pursue claims depending on what the roadblocks are there. The final thing, let me say this. We're dealing here with people who are not trying to impede, hinder, or defraud creditors. They don't already have judgments against them. We're dealing with people who are worried that maybe in the future somehow they're going to have judgments. And we want to set up a plan now that will protect them and provide them some degree of security and a nest egg that will stand up against attack. I went kind of fast and we went through this without any questions. Does anybody have any questions about anything? The question is, do I see discounts on family limited partnerships? And we're talking about the minority discount and the discount for lack of marketability and control on family limited partnerships, where the limited partnerships, where the asset is publicly owned stocks and securities. There is a recent case, and I don't have the site with me, but that did uphold it. It's more difficult, though, to substantiate and to argue. And the reason is because when you look at the discount for minority discount, you're looking at 2 factors, lack of marketability and lack of control. Well, those 2 factors are not as prevalent when you're dealing with an asset like publicly held stock, because that publicly held stock is dictated by the marketplace. Whereas real estate, it is more personal, and it depends more on the management. And so that's the reason it's harder to substantiate a discount for partnerships that own publicly held stock. But there has been a recent case that did allow it. So you can maybe do it. You just need to be very, very careful.
30%, 40 maybe?
I think the case was 25%, if I recall. And you know, my position would be if a lot of the other factors are there, if it's not somebody that is on their deathbed and they're not putting their whole estate into it, and they're not the general partner, there's another general partner. If you do it very carefully, I think you've got a shot, and it's worth a shot. Let me tell you why. At least as long as Bush is president, which isn't going to be for much longer. But Bush wanted to do away with the estate tax, and of course the Democrats wouldn't let him do it. So he did the next best thing. He reduced the budget for the estate tax division of the IRS. And that is a big thing. I mean, there is significantly less scrutiny of estate tax returns than there was in the past. And it's easier to get a deal with the IRS than it has been. On the other hand, they've now brought in 2036 as an argument against family limited partnerships, where you've retained a little string of control, and they brought it back in. So they're using that, and they never did use that before. And in the last 5 years, they've had success with that. The question is, with respect to I've suggested segregating the assets between the operating assets and the real estate. And, but the problem is that there's a rental income tax, an excess tax in Florida. There's a sales tax. We don't have that in California.
Okay, I didn't think so.
So that might be a problem here, and again, that's why you have to look at it from a Florida standpoint. Everything's state specific, but we don't have that problem. The question is, is the charging order impacted by the management structure of the LLC? And the answer to that is perhaps. The best situation for the charging order is to have it manager managed. And because then the manager is in exclusive control. If you've got members, then you might be able to, they might try to argue that they have more, the creditor has more control over the members than the manager. What we do is if a client really gets sued, he'll resign as the manager. And in some instances, we may even appoint an offshore manager so that they would have more difficulty getting control. Well, this has been a long day for you, I'm sure, and I'm sorry you had to tolerate me here at the end, but thank you for your courtesy. And